Hi, this is Manjri Singh from Law School 101 and this is a video in the Legal Aptitude series brought to you by Law School 101 for CLAT aspirants. In this video, we will be covering Law of Contracts. This is the second last video of the series. In this video, we will be covering the following topics. Number 1, compensation and warranty. Number 2, specific performance. Number 3, termination of contract. Number 4, contingent contracts. Number 5, wagering agreements. And number 6, indemnity and guarantee. This video will not cover any questions because all the questions from the previous year papers related to contracts have been covered in the previous video. So, let's begin with the first topic, compensation and warranty. Compensation for loss or damage caused by a breach of contract entails when a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby which naturally arose in the usual course of things from such breach, or which the parties knew when they made the contract to be likely to result from the breach of it. Let's look at some situations. Situation 1. A contracts to sell and deliver 50 mounds of salt beer to B at a certain price to be paid on delivery. A breaks his promise. B is entitled to receive money from A by way of compensation, the sum, if any, by which the contract price falls short of the price for which B might have obtained 50 mounds of salt beer of like quality at the same time when the salt beer ought to have been delivered. Now we move on to the next situation. A hires B's ship to go to Bombay and there takes on board on the 1st of January a cargo which A is to provide and bring to Kolkata, the freight to be paid when earned. B's ship does not go to Bombay, but A has opportunities of procuring suitable conveyance for the cargo upon terms as advantageous as those on which he had chartered the ship. A avails himself of those opportunities but is put to trouble and expense in doing so. A is entitled to receive compensation from B in respect of such trouble and expense. Now we move on to the next situation. A contracts to buy of B at a stated price 50 mounds of rice, no time being fixed for delivery. A afterwards informs B that he will not accept the rice if tendered to him. B is entitled to receive from A by way of compensation the amount, if any, by which the contract price exceeds that which B can obtain for the rice at the time when A informs B that he will not accept it. The next situation is A contracts to buy B's ship for 60,000 rupees but breaks his promise. A must pay to B by way of compensation the excess, if any, of the contract price over the price which B can obtain for the ship at the time of the breach of promise. Situation 5. A, the owner of a boat, contracts with B to take a cargo of jute to Mirzapur for sale at that place starting on a specified day. The boat, owing to some avoidable cause, does not start at the time appointed, whereby the arrival of the cargo at Mirzapur is delayed beyond the time when it would have arrived if the boat had sailed according to the contract. After that date and before the arrival of the cargo, the price of the jute falls. The measure of the compensation payable to B by A is the difference between the price which B could have obtained the cargo for at Mirzapur at the time when it would have arrived if forwarded in due course and its market price at the time when it actually arrived. A contracts to repair B's house in a certain manner and receives payment in advance. A repairs the house, but not according to contract. B is entitled to recover from A the cost of making the repairs conform to the contract. The next situation is A contracts to let his ship to B for a year from the 1st of January for a certain price. Freights rise and on the 1st of January the hire obtainable for the ship is higher than the contract price. A breaks his promise. He must pay to B by way of compensation a sum equal to the difference between the contract price and the price for which B could hire a similar ship for a year on and from the 1st of January. The next situation is A contracts to supply B with a certain quantity of iron at a fixed price, being a higher price than that for which A could procure and deliver the iron. B wrongfully refuses to receive the iron. B must pay to A by way of compensation the difference between the contract price of the iron and the sum for which A would have obtained and delivered it. The next situation is A delivers to B, a common carrier, a machine to be conveyed without delay to A's mill, informing B that his mill is stopped for want of machine. B unreasonably delays the delivery of the machine and A, in consequence, loses a profitable contract with the government. A is entitled to receive from B by way of compensation the average amount of profit which would have been made by the working of the mill during the time that delivery of it was delayed, but not the loss sustained through the loss of the government contract. The 10th situation is A, having contracted with B to supply B with 1000 tons of iron at 100 rupees per ton to be delivered at a stated time, contracts with C for the purchase of 1000 tons of iron at 80 rupees a ton, telling C that he does so for the purpose of performing his contract with B. C fails to perform his contract with A, who cannot procure other iron, and B, in consequence, rescinds the contract. C must pay to A 20,000 rupees, being the profit which A would have made by the performance of his contract with B. The 11th situation is A contracts with B to make and deliver to B by a fixed day for a specified price a certain piece of machinery. A does not deliver the piece of machinery at the time specified, and in consequence of this, B is obliged to procure another at a higher price than that which he was to have paid to A, and is prevented from performing a contract which B had made with the third person at the time of his contract with A, but which had not been communicated to A, and is compelled to make compensation for breach of contract. A must pay to B by way of compensation the difference between the contract price of the machinery and the sum paid by B for another, but not the sum paid by B to the third person by way of compensation. The 12th situation is A, a builder, contracts to erect and finish a house by the 1st of January in order that B may give possession of it at that time to C, to whom B has contracted to let it. A is informed of the contract between B and C. A builds the house so badly that before the 1st of January it falls down and has to be rebuilt by B, who in consequence loses the rent which he was to have received from C and is obliged to make compensation to C for the breach of contract. A must make compensation to B for the cost of rebuilding the house and for the rent loss and for the compensation made to C. The next situation is A sells certain merchandise to B, warranting it to be of a particular quality, and B, in reliance of this warranty, sells it to C with a similar warranty. The goods prove to be not according to this warranty, and B becomes liable to pay to C a sum of money by way of compensation. B is entitled to be reimbursed this sum by A. The next situation is A contracts to pay a sum of money to B on a day specified. A does not pay money on that day. B, in consequence of not receiving the money on that day, is unable to pay his debts and is totally ruined. A is not liable to make good to B anything except the principal sum he contracted to pay together with interest up to the day of payment. The next situation is A contracts to deliver 50 mounds of saltpeter on the 1st of January at a certain price. B afterwards, before the 1st of January, contracts to sell the saltpeter to C at a price higher than the market price of the 1st of January. A breaks his promise. In estimating the compensation payable by A to B, the market price of the 1st of January and not the profit which would have arisen to B from the sale to C is to be taken into account. The next situation is A contracts to sell and deliver 500 bales of cotton to B on a fixed day. A knows nothing of B's mode of conducting the business. A breaks his promise, and B, having no cotton, is obliged to close his mill. A is not responsible to B for the loss caused by B by closing his mill. The next situation is A contracts to sell and deliver to B on the 1st of January certain cloth which B intends to manufacture into caps of a particular kind for which there is no demand except at that season. The cloth is not delivered till after the appointed time and too late to be used that year in making caps. B is entitled to receive from A by way of compensation the difference between the contract price of the cloth and its market price at the time of delivery, but not the profits which he expected to obtain by making caps, nor the expenses which he has been put to in making preparation for the manufacture. The last situation is a ship owner contracts with B to convey him from Calcutta to Sydney in A's ship sailing on the 1st of January, and B pays to A by way of deposit one half of his passage money. The ship does not sail on the 1st of January, and B, after being in consequence detained in Calcutta for some time and thereby put to some expense, proceeds to Sydney in another vessel and in consequence arriving too late in Sydney loses a sum of money. A is liable to repay to B his deposit with interest and the expense to which he is put by his detention in Calcutta and the access, if any, on the passage money paid for the second ship over the agreed upon for the first, but not the sum of money which B lost by arriving in Sydney too late. We hope the situations have made things a little clearer. Now let's move on to our next topic, specific performance. In certain contracts, awarding damages for breach remains inadequate. Hence, a special remedy for specific performance exists in which the court instructs the breaching party to honor the contract. Termination of contract. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. A contract may also be terminated if it becomes impossible to perform. Let's look at some situations. The first situation is a singer enters into a contract with B, the manager of a theatre, to sing at his theatre 2 nights in every week during the next 2 months, and B engages to pay her 100 rupees for each night's performance. On the 6th night, A willfully absents herself from the theatre. B is at liberty to put an end to the contract. The second and last situation is a singer enters into a contract with B, the manager of a theatre, to sing at his theatre 2 nights every week during the next 2 months, and B engages to pay her at the rate of 100 rupees for each night. On the 6th night, A willfully absents herself. With the assent of B, A sings on the 7th night. B has signified his acquiescence in the continuance of the contract and cannot now put an end to the contract, but is entitled to compensation for the damage sustained by him through A's failure to sing on the 6th night. Contingent and wagering agreements. A contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. For example, A contracts to pay to B 10,000 rupees if B's house is burnt. This is a contingent contract. Contingent agreements to do or not do anything if an impossible event happens are void whether the impossibility of the event is known or not known to the parties to the agreement at the time when it is made. For example, A agrees to pay B 1,000 rupees if 2 straight lines should enclose a space. The agreement is void. B. A agrees to pay B 1,000 rupees if B will marry A's daughter C. C was dead at the time of the agreement. This agreement is void. Contingent contracts to do or not do anything if a specified uncertain event happens within a fixed time become void if at the expiration of the time fixed such event has not happened, or if before the time fixed such event becomes impossible. When contracts may be in force which are contingent on a specified event not happening within fixed time. For example, A promises to pay B a sum of money if a certain ship returns within a year. The contract may be enforced if the ship returns within the year and becomes void if the ship is burnt within the year. The next situation is A promises to pay B a sum of money if a certain ship does not return within a year. The contract may be enforced if the ship does not return within the year or is burnt within the year. Contingent contracts to do or not do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts become void. For example, A makes a contract with B to buy B's horse if A survives C. This contract cannot be enforced by law unless and until C dies in A's lifetime. The second situation is A makes a contract with B to sell a horse to B at a specified price if C, to whom the horse has been offered, refuses to buy him. The contract cannot be enforced by law until and unless C refuses to buy the horse. The last situation is A contracts to pay B a sum of money when B marries C. C dies without being married to B. The contract becomes void. Now we move on to wagering agreements. Agreements by way of wager are void, and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or any other uncertain event on which any wager is made. There is an exception, which are favor of certain prices for horse racing. Now the difference between contingent contracts and wagering agreements. There are quite a few differences that exist between contingent contracts and wagering agreements. These are: number 1, while contingent contracts are valid, wagering agreements are void. Number 2, in contingent contracts, the happening of an uncertain future event is a collateral. It is not the main object of the agreement, and therefore in these contracts there may or may not be reciprocal promises in relation to the happening of the uncertain event specifically. In wagering agreements, the happening of an uncertain future event is the main element of the contract. The reciprocal promises or consideration is based entirely on this uncertain event. Number 3. Usually in contingent contracts, both parties have an interest in the contingent event. However, in wagering agreements, the event is not of interest to the parties. Only the outcome concerns them, because their interest is only in winning or losing the bet. For example, a contingent contract is a building developer entering into a contract for the sale of the building constructed on a particular piece of land for a specific amount on the contingent condition that the builder gets the approval of the licensing authority and the clearance authority. In this contract, the main object is the sale and purchase of the building. The permission from the authorities is only a collateral clause in which both parties have an interest. An example of a wagering agreement is, say, two individuals placing a bet on whether the developer gets the permission from the authorities. Here, the two individuals are not interested in the event, only the outcome. Also, it forms the main object of the agreement. Now we move on to our last topic for this video, indemnity and guarantee, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called a contract of indemnity. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. A guarantee may be either oral or written. Thank you for watching this video. For more resources, follow, like, and share our Law School 101 page on Facebook. Subscribe to our main YouTube channel by the same name for more videos. We also encourage you to post your doubts, queries, and questions in the comment section below. These will be replied to within reasonable time. Best of luck, law aspirants.